Oyez, oyez, oyez. All persons having any business with the Honorable Supreme Court of Maryland, draw near and give your attention. The court is now in session. God save this state and this honorable court.
Good morning. Please be seated. Welcome to the Supreme Court of Maryland. We have two matters on the docket this morning. We're going to start with case number 31, Cromartie versus State. Mr. Sharifi, you've saved 15 minutes for rebuttal.
Yes, Your Honor.
Please proceed.
Thank you, and good morning. And good morning to everyone here. Mr. Chief Justice, and may it please the court. I'd like to start, if I may, with a question. What is the purpose of the rules of evidence? What is the purpose of the rules of evidence? Well, if you look at Maryland Rule 5-102, titled Purpose, it tells us, part of that rule says that the purpose of the rules of evidence is so that the truth may be ascertained and proceedings justly determined. And the way to make sure that the truth is ascertained and proceedings are justly determined is to be mindful and emphasize the reliability of evidence. The rules of evidence are in place to ensure the reliability of the evidence that the fact finder is consuming. That's why we have rules against hearsay. That's why we have what we call the best evidence rule. And that's also why we have the rule on witnesses. And so the question in this case is whether allowing Detective Moore to sit at counsel's table and listen to another witness testify before testifying himself enhanced the purpose of the rules of evidence and the reliability of the evidence that the jurors heard in this case. And the answer to that has to be no. The more you loosen the rules on sequestration, the less reliable the evidence becomes. Your Honors, I ask today that this court rule that police officers, law enforcement officers, hereafter may not in Maryland be designated as state representatives and thus exempt from the sequestration rule. It is a bad rule. It is a bad rule for policy reasons, and it is inconsistent with Maryland case law dating back decades. Poole was wrongly decided. Now, as any attorney knows, there are strengths and weaknesses to most cases, and I recognize that back in 1993, the Rules Committee submitted a recommendation when this court decided to adopt Title V, Maryland Rules of Evidence, stylistically to be similar to the federal rules of evidence, and I understand that the Rules Committee suggested language in the rule and proposed Rule 5-615 saying that the representative provision in 5-615 would not apply to the state in criminal cases, and that that language was struck when the rule was promulgated. But the question is, in this case, as it relates to the continued viability of Poole, the question is, in this case, was the striking of that language, did the striking of that language change Maryland law up to that point. Because this court in 1978 in Johnson said expressly, albeit while interpreting a different rule, said expressly that police officers and law enforcement agents are not exempt from sequestration. They are not. That was Maryland law. That was Maryland law until Maryland adopted a set of evidence rules that, again, in substance in large part, but also in style, mirrored the federal rules of evidence.
You say that it's a bad rule. Has there been any movement in the federal courts to change the way the federal criminal cases operate, where agents routinely sit next to prosecutors and at times testify at trial? Has there been a groundswell to change that?
Not that I've seen, but Justice Biran, I think one thing that is important in kind of assessing that question is the fact that federal common law always permitted this practice. Federal common law permitted this practice before the promulgation of the federal rules of evidence. That's how that's why the federal rule and the Maryland rule, although written similarly, have very distinct histories. So there has not been, as I can see, as Your Honor put it, like a groundswell of movement towards removing this rule, but that would be inconsistent. Such an action would be, or such an effort would be inconsistent with the federal common law. Whereas in Maryland, what we are asking for is consistent with decades of Maryland case law. And
The first time
yes.
we interpreted the plain language of this particular rule and the text of this rule, and I've heard you talk about the purpose of the rule as well as policy.
Yes.
And even if we were to agree that whether it's good or bad policy, starting with the plain language,
Yes.
as we always do, isn't it pretty clear that the rule itself uses the word shall? The court shall exclude, pursuant to this rule, officers or parties. So can you tell us how your position is consistent with the plain language of the rule?
Yes. So, yes, Justice Booth, the plain language does, but what the plain language doesn't say that law enforcement officers are exempt from sequestration. The plain language says that a party that's not a natural person may designate a witness as a representative. And Poole interpreted that to mean that the state can designate a police officer or law enforcement to be a representative, thus exempt from sequestration. So the issue is twofold, as I see it in response to your question. Number one is the word representative. So yes, the plain language has the word representative. It doesn't say police, it doesn't say detective, it says representative. So the question is whether or not that term representative would apply to police officers and detectives in terms of their relationship with prosecutor offices. And so my first response would be that the police officer prosecutor office relationship is not such that a police officer is a representative of the prosecutor's office. And it has never been in Maryland. In fact, under 4-321, the predecessor to 5-615, the Attorney General back in 1988 asked that there be a provision exempting law enforcement officers from sequestration under the old rule 4-321, which had this representative language in it. And the Rules Committee said, no, that's not consistent with Maryland law. So
It does look like, though, when this court and our predecessors considered this particular rule, the legislative history kind of confirms the plain language interpretation that the court did not intend to exempt out police officers from the plain language interpretation of representative?
I think that comes down to whether or not striking the Rules Committee suggestion that the state, that it doesn't apply to the state and law enforcement officers. It comes down to, if you distill it down to its finest point, whether that the striking of that language, rather than any overt language, right? The striking of that language, whether that essentially superseded the holding in Johnson. But
I
yeah.
want to push back a little bit on the language that's here, because it doesn't say a representative of a party. It says an officer or employee of a party, so that's who you start with, designated as its representative. So you don't have to start with somebody being a representative. It gives the non-natural party the right to designate somebody, and they become a representative by the designation. So the first part, an officer or employee, a police officer is an officer or employee of the state, right?
I wouldn't agree with that per se.
So explain how that's not true.
So first of all, I think that the officer and employee language is not entirely disconnected from the word representative. They're read in unison. And the word representative typically is more applicable to civil cases. Typically, representative of an estate, a corporate officer in relation to a corporation. It's typically civil case type parlance. And so if you think about what representative is in those terms, typically it's referring to the civil context. Then go back and evaluate officer and employee. Officer probably means something like chief financial officer or a CEO or somebody that can sit there on behalf of a corporation and advise counsel. Does it mean police officer or a detective in relation to a prosecutor's office? Obviously, that's for this court to decide. I would submit no, based on the word representative and history of Maryland law. It has never been in Maryland that a representative of a prosecutor's office can be a police officer, particularly because sometimes you might have like a city officer on a case being prosecuted by, say, the Montgomery County State's Attorney's Office, let's say, prosecuting a case, and then they have a Rockville City police officer, for example, or police detective.
Excuse me for interrupting, but
Sure.
the party here is not a particular state's attorney's office, it's the state of Maryland. So how is a police officer not at least an employee of the state of Maryland? Because
not every police officer is an employee of the state of Maryland. The state troopers would be, but not a county police officer or a city police officer. And so in terms of officer and employee, Mr. Chief Justice, to your question and answering Justice Barron's question, I agree. It doesn't just say representative. It says officer or employee designated as a representative, but they're read in unison. And if you think about that, is the relationship between a police officer and a prosecutor's office an employee-employer relationship? No.
To Justice Barron's point, the state of Maryland as an entity is the people of Maryland. So why can't a police officer be a representative of the people there to assist the prosecutor? We don't require in civil cases that the attorney who is representing a civil client have some direct connection to that client, and therefore a representative of that client, a corporate representative, a CEO, chief financial officer, or even a custodian of records could be the representative for that corporate client, which has no connection to the office or of the attorney or the firm from which that attorney works. So why is there a difference?
Well, Justice Eves, the Maryland law has never, there's no authority in Maryland law that provides for that proposition, that because the state of Maryland represents the people of the state of Maryland, that a police officer can therefore be a representative of the state. And again, the idea of the representative, and I understand, and if I may go into my rebuttal time to answer, thank you. The idea is whether or not a representative includes a police officer or a detective for the state. And beyond whether or not as a matter of law it should, then we have the secondary question that I'm happy to address here in my opening argument, because I have, I think, sufficient time for rebuttal. The second issue is whether or not that idea, let's assume for the sake of argument that this court finds that police officers and detectives can be designated as state representatives in certain cases. Then the question becomes, is that rule discretionary or is it mandatory? And that is a second piece in this. And I would submit that if anything, it is a discretionary, not mandatory rule. And the reason is because, notwithstanding the shall not exclude language, the federal court, the federal rule, I should say, has very similar mandatory sounding language that this rule does not authorize. That's the rule, that's what Federal Rule of Evidence 615 says. This rule does not authorize. So it's equivalent to shall, I would submit. Yet in federal court, every single federal circuit, the only one that's a little bit of a holdout is the Sixth Circuit, which went one way in 1990 and had differing language in 1991. Every single federal circuit, everyone, has said this rule is discretionary. Every single one. So if Maryland now, if this court was to do what the state is asking, the state is going to ask not only that the police officer and the detective be able to be designated as a representative, not only that, but the state is going to ask this court to implement a rule in Maryland that when a prosecutor says this police officer or this detective is my representative and therefore doesn't need to go outside when other witnesses testify, the detective or the police officer is going to sit here, listen to all the evidence, and then testify, that the trial judge has no discretion, simply can do nothing about it, has to just accept that designation, which opens the door for the state to essentially identify a witness, a law enforcement officer that they want to have exempt from sequestration, and just designate them as the representative. There has to be gatekeeping at a minimum as to who the representative is. Applied to this case, for example, Detective Moore, this is not the type of federal RICO case with tens of thousands of documents that a IRS agent or something like that has gone through and maybe the prosecutor needs that person's assistance. This is essentially a witness that testified after the first witness based on what the first witness testified to.
You said based on.
Yes.
Where is that in the record? What did he say that he didn't know previously from his investigation? Or Detective Moore?
Well, Justice Kilo, let's assume for the sake of argument that Detective Moore testified based on what he learned during the investigation. And I know the state puts some heavy emphasis on this. That's still improper, going back to the point of reliability. Just because a detective learned something during their investigation from another person, which is what happened here, Detective Moore from Hayes, that doesn't allow Detective Moore to testify based on what Hayes told him or based on what he learned from Hayes.
Right, but didn't he testify regarding a video, the surveillance video that was already in evidence?
Yes.
And as the officer in charge, he investigated the scene, and he narrated where he went or where things were located based on his own personal knowledge?
That, of course, would be admissible based on personal knowledge. That I picked up shell casing A from this location, I picked up shell casing B from this location. But that's not all that happened.
Well, the only objection was when he characterized the incident as a chase, correct? He characterized Mr. Cromartie.
Yes, that was part of the, that was certainly evidence that drew an objection, but the objection was a general objection. It was an objection that was overruled, and the trial court, when overruling the objection, expressly said, well, he was in the courtroom when that happened, I'm going to allow him to do that.
What do you mean general objection? He objected based on the characterization of how Detective Moore said that he chased him across the parking lot.
That came after. If you followed through the transcript, first there was an objection, then the judge overruled the objection, then counsel said it's to the characterization, and then there was a second ruling on that. And so if we watch the video, it's very, very difficult to tell in the video. It's near impossible if you don't know the individuals or haven't seen them before, who is who. It's near impossible to tell who is who. So the only way that Detective Moore would be able to identify who went where and who did what is based on either what Hayes told him pre-trial or what he learned from Hayes while Hayes testified.
So trial counsel did not request a continuing objection, right?
As to
the general or the specific objection.
No, there's no request for a continuing objection.
So why isn't that a problem for your argument with respect to any question other than the one to which there was an objection?
Because I think when we're talking about waiver and preservation, we look at not only the nature of the objection, but also the ruling. And the ruling was definitive when the trial court said, well, he sat there and he watched the video with the rest of us, or he's been here just like the rest of us, overruled. So, again, because preservation and waiver, it should not be a hyper-technical endeavor. It should make sense that the trial court had an opportunity to decide whether or not evidence was admissible or inadmissible. And if you read the trial court's language in the ruling, it appears to be definitive that the trial court decided that Detective Moore could testify to what Detective Moore has already heard in court.
Well, I mean, your time is running. We can talk about rebuttal. I don't see that in the transcript.
Yeah, it is. If Your Honor, does Your Honor have, by chance, my reply brief? The reply brief, I think I kind of dissected, I think, as carefully as I can, and the reply brief kind of breaks down the objection, then the ruling, then the follow-up with the characterization. And I'm happy to answer more questions on that in my rebuttal. If there are no further questions?
I don't see any, so you'll have about a little over 7 minutes for rebuttal. Thank you, Mr. Sharifi, and we'll hear now from Ms. Treaster.
Thank you.
Thank you, Mr. Chief Justice. Your Honors, good morning. May it please the Court, Kristen Treaster for the State of Maryland. My colleague just said to this Court, it is a bad rule. And he suggested that the state is asking this Court to implement a rule. What that means is that he recognizes that the rule as it is written allows the prosecutor, the state's attorney's office, to designate a police officer as its representative for trial. Mr. Cromartie doesn't like that rule, and he's asking this Court to change it. With the utmost respect to this Court and your ability to implement new rules, this is not the way to do it. It needs to go through the Rules Committee and through the normal rulemaking or rule amending process. This Court specifically considered the phrase, "but in a criminal case, the state shall not be so represented," It considered that phrase and it struck it. It rejected it. It chose not to include it. And that leaves us with the rule that we have today.
Perhaps that language was not included in the amendment phase because our common law already accounted for the circumstance that the except clause was writ large in our common law.
And Your Honor, I recognize that the Maryland common law previously did not allow that. There's no way around that. But the entire purpose of adopting Title V in 1993 was to more closely mirror, I believe that the court used the word pattern, Title V after the federal practice. And the federal practice had always been to allow the police officer to be designated as a representative. So our common law changes regularly. Our history is riddled with examples of where either the court, through making a rule, or the General Assembly, through making a statute, has altered or flat out changed the common law. So the fact that this rule contradicts our common law does not have any bearing on what it means now. We need to look at
In the legislative history and the rules-making process that we intended to abrogate or overrule.
That's true. That's true, Your Honor. I did not find anything in the process that says we choose to abrogate the common law. You're absolutely right. But if you look at all of the context surrounding the discussion of Rule 5615 and how it compared to the federal law and the intent and expressed intent to pattern it after the federal law, I think the intent of the court is clear that they intended to allow the state to designate a law enforcement officer as its representative to assist it in trial.
I understand in the civil context, a trial attorney on behalf of a business or a corporate entity or a partnership needs a representative there because it's the representative who makes decisions about the case, to settle the case, or just in some instances, general trial strategy. My question to you is, I understand your plain language argument, but what is the reason that the trial attorney needs an investigative officer who is also going to be a witness?
Your Honor, in many cases...
Let me just add to that question,
Sure.
Just so you know where I'm going. It's the lawyer representing the state that makes all decisions, the key decisions about whether to offer a plea deal, for
Sure.
example. So it's very different from the civil context.
Your Honor, the representative in these criminal cases is not there to make decisions on behalf of the state. It's there to assist the prosecutor in trying a case that might involve investigations that are very complex, financial crimes trials, wiretap trials, those more complex cases where the trial attorney may not be an expert in that field. You can't ask a prosecutor to also be a CPA, for example, to know every in and out of evidence pertaining to financial crimes. So the purpose of the party representative in these cases is not to make decisions, but to help the prosecutor put on the clearest and most comprehensive case that they can, which of course is the same role that the defendant plays on the other side of the table. The defendant is constantly whispering into the attorney's ear, oh, don't forget to ask this question, and no, this is what really happened, things of that nature. So allowing the state to have a representative to assist it in presenting its most clear case is a matter of fairness, quite frankly.
Addressing the plain language of the rules, can you explain why a local police officer would be an officer of the state?
Well, Your Honor, we have to remember that the phrase is an officer or employee. But certainly, I believe it was Justice Eves pointed out that the state is really a short term for the people of Maryland. And the police do act on behalf of the people of Maryland. But I would point out that we could be very, very technical about it and say that the Maryland State Police, who are clearly employees of the state of Maryland, but if we do that, then you're creating a rule where the more rural counties who depend on the state police are allowed to have police officers as party representatives, but more populated counties that have their local or county sheriff's departments or police departments are not allowed to have the representative. So that...
But that dichotomy would only exist if we accept the premise of your view of the legislative history and the plain meaning of the entire clause of this rule.
I'm sorry, I didn't quite hear you, Your Honor.
That dichotomy would only exist if we accept your view about the meaning of the legislative history and the plain language of this rule.
The plain language of officer or employee, you mean? Your Honor, most respectfully, particularly to my colleague, the meaning of officer or employee was never brought up until this argument. In fact, it was so not brought up initially that I believe I dropped a footnote saying he did not dispute that police officers are officers, employees of the state. So this, I don't think is...
That doesn't mean we cannot raise it.
Of course you can, Your Honor, always.
And it seems to be the language that's most critical to the interpretation of the rule, because to qualify to be designated as a representative, the person must first be an officer or an employee.
That's true. And I would direct the court back to the purpose of the rule, which is to pattern it after federal practice, which allowed law enforcement to assist the prosecutors. And the phrase that this court struck or rejected when it adopted the rule was, in a criminal case, the state shall not be so represented. So clearly the court contemplated exactly this scenario. It wasn't contemplating civil cases when it struck that phrase, because the phrase started with except in a criminal case. So if you look at both the language that the court struck and the reasoning it struck it, which was because it wanted to follow the federal practice, all of those factors merge to an understanding that the state can designate a police officer to be its representative.
Are you aware of any case law that endorses the proposition that the state, for purposes of this rule, is to be viewed as the people?
I can't cite a case to Your Honor, but the prosecutor's office represents the residents. We're not trying to enforce an administrative rule that the state has promulgated or something where the state is its own business entity, if you will. In the criminal world, the prosecutors represent the people who live in their vicinity. So particularly in the criminal world, I don't think there's much dispute that the prosecutor's office represents the people. We just call it the state because it's easier. Many, and I know Your Honor can come up with examples of states who call themselves the people of Illinois or the people of whatever state.
The state is a recognized party.
Yes, the state is the party, yes.
And to the extent that this rule identifies parties and who may be an officer or an employee of a party, in the absence of any case law identifying the state as amorphously the people, aren't we bound to apply the definition of the state as a party and determine whether an officer is an officer or an employee of the state as a party?
You know, I go back, and I understand your point. But if you apply such a strict interpretation as Your Honor is proposing, then you end up with that dichotomy where only agencies who use the state police can have designated representatives, whereas counties who have their own police departments cannot. And that doesn't make any sense. That can't be the intent of the rule.
But under your strict interpretation, you have a different dichotomy, which is in a civil case where people are only fighting about money, the lawyer does not, the representative is there on behalf of the company to be able to guide the attorney on decisions that only the company can make. In the criminal context, you don't have that. And what your rule allows is a witness who can sit through the entire trial and watch everybody testify and then testify him or herself.
So,
So that's a dichotomy also. So which dichotomy is
well,
worse?
first, I don't necessarily agree with the idea that in a civil case, the party representative is there only to make decisions. I
No,
think
not only, but I can't speak for every corporate lawyer who's tried a case on behalf of a business, but in my experience, it's always been somebody who can make decisions, who has authority to make decisions for the company, who also might be a witness, that's true. But that person is there because the attorney doesn't have the authority to make those kinds of decisions, to make certain kinds of decisions.
right, but just because that is normally why a civil party might have a representative doesn't limit the representative to that purpose. They are also there to assist the attorney. I won't call him, prosecutor comes naturally, but they're also there to assist the attorney to present their case as clearly and as thoroughly as possible. So just because they usually play one role does not limit the roles that they can play. And the rule doesn't limit the roles that any party representative can play. It simply says that a non-natural person party may designate a representative.
Counsel, was this argument even preserved as to whether or not Detective Moore had the capacity to sit as a representative or agent of the state?
It was not, Your Honor, and I thank you for asking that question.
As I read the transcript, the objection seemed to be based on the timing of the designation, not whether he had the capacity to serve as a party or representative of the state.
That's correct, Your Honor. The defense attorney objected because there was an issue about whether he should have been designated before the trial started or simply before the testimony started. And the court looked at Rule 5615 in its plain language and said, no, it's fine for him to be here. There was no discussion or suggestion that there was something inherent in Detective Moore that prevented him from being a representative. So I agree with you, Your Honor. This was not preserved in terms of what the definition of a representative is or whether a police officer can be a representative. I also would argue that the meaning of the word shall in terms of whether the court has discretion or not is equally unpreserved, and for the same reason. The defense attorney did not say, well, Your Honor, I recognize that you're allowing the state to designate somebody, but I don't think this is the right person. And so that mandatory versus discretionary nature of the decision is also not properly before this court.
Can I ask you a question that I asked the defense counsel, appellate counsel, and he has a chance to he's hearing this, so he can respond to it. But I'm reading his appellate brief, his reply brief, and it says, and I read it to you. He says, question and answer. And when Mr. Smith was chased, there's an objection by defense. He says, and the court overruled the objection. Then the defense counsel said, can we approach? Court says, I'm going to sustain that because no, I'm going to overrule that. He was present when the video was shown, when the witness indicated who was on the video, so overruled. Defense replies, it's to the characterization, Your Honor. And then that's when the court says, all right, jury will make their own decision as to whether someone was chased or not. In his appellate brief, reply brief, it says that there were two objections. I only see one. You have want to comment on that?
Your Honor, I thank you for bringing that up also. That leads me right into the second part of my presentation. I entirely agree with Your Honor's interpretation of that. There was one objection, and the court thought, perhaps, I'm speculating as to what the court thought, of course, but the court appeared to think that it was about the officer's description of the video. But then the defense counsel corrected the court and said, no, I'm not objecting to that. I'm objecting to the characterization of the word chased and whether Mr. Smith was actually being chased, or perhaps was he being followed, or perhaps was he leading, whatever other adverb you'd like to use. But the defense attorney clarified his objection when the court misinterpreted it and said, no, I'm objecting to the characterization of the person being chased. And we can tell that even more definitively if we look at all of the questions and answers in that section, and specifically when the objection was made. Because the state asks, so earlier, when the jury heard from Mr. Hayes and he talked about walking out of the building and he can be seen going behind an SUV, can you show the jury where on this sketch that area represents? So the state had clearly referred to the playing of the video in the courtroom, and that did not draw an objection. The detective answered, all right, so from the video that we all saw, this represents the building here, which is number 1165. This is where they ran out. We're going to switch sides. This is the adjacent side, and this is closest to here. Again, he is talking all about this video that was played in the courtroom. There is no objection. It's only when he says that Mr. Smith was being chased that the defense attorney lodges its objection. So when you look at that entire section of the transcript in toto, it becomes even more clear that he was only objecting to the characterization of Mr. Smith being chased. No further part of that was preserved for appellate review.
I mean, I won't read the entire transcript, but there were certainly other instances in the transcript after that where both on direct and in cross-examination, the questions related to the identity of the people on the videotape.
That's correct, Your Honor. And from reading the entire transcript, both opening statements, closing arguments, all of the testimony, it's clear that there was never any dispute as to who did what in this trial. This was a case about self-defense and Mr. Cromartie's reasoning for doing what he did.
I want to ask you about the plain language. The rule as I read it requires the rule on witnesses to be invoked before the testimony, before the trial starts.
Before the testimony starts, yes.
Okay. Then there's a provision, I think it's the third sentence. The court may order the exclusion of a witness on its own initiative or upon the request of a party at any time.
Right.
So does the court have discretion upon the request of the defendant to exclude the representative
No,
at some point during the trial?
No, and that is because Section B2 or subsection B2 says the court shall not exclude under this rule the following people, and in that list is the party representative. I also want to turn, if I may, to my colleague's question, I suppose he poses it as a question, about whether Rule 5615 allows the representative to provide lay opinion testimony based on earlier testimony. And I will answer that question substantively in a moment, I promise. But I want to point out three things. One, it is absolutely not preserved. As I just discussed, there is no objection in here that references an opinion. Secondly, it was not an opinion. He's talking about the video, but he's not opining about the video. He's referring to it. He's saying where events in the video occurred on a crime scene sketch. There is no opinion in that testimony. And finally, it was not based on previous testimony because he had already seen the video in his investigation. He had already heard the Mr. Hayes' statements and so on and so forth. So on all three of those bases, that question is not before the court. But if...
Can I ask you a question? But
sure.
Doesn't Chase, though, sort of suggest more than just an observation? I mean, it sort of suggests an element of intent or purpose.
The Chase, did you say?
Yes, the Chase.
Yeah, I agree, yes. But the court sustained that objection. So that's, they got what the defense received the remedy they asked for in terms of the Chase part.
Where did they sustain that objection?
Your Honor, the court didn't use the word sustained, but he did say, all right, the jury will make their own decision as to whether someone was chased or not. So I read that as in essentially sustaining or implicitly sustaining that objection. I mean, I agree with you, being chased is an opinion, but I read that as being sustained.
All right, well, we can agree to disagree.
Okay. But I want to answer the question substantively about whether Rule 5615 allows the representative to provide opinion testimony based on earlier testimony or based on anything else. And the answer to that is that Rule 5615 does not affect the other rules of evidence. So in this case where Mr. Cromartie is alleging improper opinion testimony, if he had objected and said, Your Honor, that's an opinion, then the court would have turned to Rule 5701, I believe it is, that says a lay opinion has to be based on the rational perception of the witness. And the court would have evaluated whether that had happened or not and would have decided whether the testimony was acceptable. But that analysis happens under Rule 5-701. It does not happen under 5615. And the same thing applies to any other kind of evidence. Our evidence is controlled by a whole book of rules. Rule 5615 does not affect any of them.
Counsel?
Yes.
Did Title V replace all common law rules on evidence?
Your Honor, I have to admit I can't say that I know all of the common law rules, but I would suggest that it only replaced the common law that it addresses. So I don't have the historic knowledge to go through them one by one and say whether any particular Title V rule was encompassed or different in the common law.
Because subsection B begins, it says, a court shall not exclude pursuant to this rule.
Mm-hmm.
So what I'm wondering is, does that apply if a common law rule of evidence survived Title V? Survived the enactment of Title V?
You're talking about a common law rule unrelated to witness sequestration?
No, the common law rule related to whether investigative officers could be a representative.
Your Honor, my argument is that Rule 516 and this court's adoption of it abrogated whatever common law was contrary to it, whether it's in this rule or another rule. The court specifically considered the common law. It specifically considered the federal practice, and it chose to follow the federal practice. So it abrogated the common law as it conflicts with the common law, it abrogated the common law.
So, speaking of the federal practice, I know your primary argument is that the discretionary versus mandatory nature of this is not preserved. But if we were to decide to reach that, how do you respond to the argument that since this was intended to adopt the federal practice or the federal guideline and federal courts have construed theirs to be discretionary, that ours is nonetheless mandatory?
Your Honor, my answer to that is that if you look at all of the discussion, both that the Rules Committee had and that this court had and that the two had together, it all deals with whether the state should be included in the rule or not. I did not find a single phrase that dealt with whether this rule should be mandatory or discretionary. So without a reason to go against the plain language, I think we need to go with the plain language, which says shall or shall not. So.
Can I ask you a question about the issue that the appellant has raised regarding the potential for jury bias in seeing a police officer sitting next to the state's attorney, and how you think this court should, or whether this court should consider that in making its ruling?
Well, Your Honor, I discussed in my brief several ways that both the trial judge and also the defense attorney can address any perceived bias or anything that they've learned during the course of anything that the witness testified to that may or may not have come from previous testimony. In terms of bias, whether the jury would give more credence to the prosecutor, for example, I believe it's a mandatory voir dire question. Certainly every trial I've ever done or read has a voir dire question that says, do you naturally believe police officers more than other people just because of their job description? And so that would identify any potential jurors who do, in fact, give police officers more credence. In addition to that, everybody just knows that the police witnesses are associated with the state's attorney's office. So whether they, sit next to them or wait out in the hallway and they're passed, in the hallway, the jurors know that the police and the prosecutor, to use a very colloquial saying, are on the same side. So the fact that an officer sits next to the prosecutor, I don't think changes the overall perception either of the officer or of the prosecutor.
Well, do we need to weigh in on that? I mean, having a police officer sit there at counsel's table is a two-sided coin, right? I mean, he's subject to being called as an adverse witness in the defense's case, just like a corporate representative. If he's sitting there at table in a civil trial, he's subject to being called at trial as well.
Sure.
Even if he's not on witness list. So, I mean, do we need to delve into that? I mean, that's a risk the state takes, doesn't it? Whenever it has an officer designated as a party, sitting at the table?
It does, Your Honor, and I would also note that in particularly today's world, it is not safe to assume that people like police officers or respect them more than other people. That is far from a sure assumption nowadays. So again, Your Honors, this court already addressed this question back in 1993, as my colleague seems to acknowledge when he says this is a bad rule. If the court disagrees with some policies underlying the rule, then certainly there is a process to address that. But the rule says what it says, and it says that any non-natural person party may designate a representative to be exempted from the sequestration order. That's where we are here. This court considered a phrase that would exclude the state from that exemption, and it rejected it. So I would ask the court to maintain the 30-year-old interpretation of this rule, the 30-year-old meaning of this rule, and affirm Mr. Cromartie's convictions.
Okay, I see no further questions, so thank you, Ms. Treaster.
Thank you, Your Honors.
Mr. Sharifi, you have the slightly more than 7 minutes that you've reserved for rebuttal.
Thank you again. Let me pick up where the state left off. The state said, in order to add, I guess, a little bit of emphasis to their argument, the state is trying to suggest that the rule as it is now is some sort of firmly rooted rule that we have been following for 30 years. That's not true. The rules were promulgated in 1993, but Poole was decided in 2012. It's only since Poole that we've had this interpretation of 5-615. So, in fact, it's only been 13 years that Maryland law has permitted this compared to the law from 1978 in Johnson.
I didn't see anything in any of the briefs to describe what was going on in courts before Poole. Are you suggesting that there's evidence that we can take cognizance of that police officers were excluded pursuant to 5-615 before that?
No, there's no, I don't think, neither me nor my opponent, I think, have identified what was going on exactly between 93 and 2012. Poole is the first case that brought it to light, if you will. But I think I don't think that's accurate to say that it's been now 30 years that we've been doing this. In fact, to your point, Mr. Chief Justice, I don't think there's any evidence of that at all. All we know is what's been going on since 2012 in Poole. A couple of points that I want to address that came up during my opponent's argument. So first on the, and I have some bullet points here that I'm going to go through, and of course, any questions. I would love to answer any questions that you might have on these bullets. The first thing is this idea of representative and the relationship between law enforcement or a police officer and the state's attorney's office. When we're trying to determine whether or not a person is an officer or employee or representative, if there's any sort of ambiguity, of course, we can maybe look elsewhere. Whether or not there's ambiguity, of course, is a preliminary issue that one must decide. But let's assume that there is a bit of ambiguity. Of course, our view is that the police officer is not an officer or employee that can serve as a representative. But let's think about a rule that we all learn within a couple of weeks of evidence class, which is the party admission rule. The party admission rule that anything a party says can be used against them by their opponent in court. The party admission rule in Maryland, under a case named Bellamy, the rule is 5-803. The party admission rule says that a prosecutor's statement can be used against the state as a party admission. But there's nothing in Maryland that says a police officer's statement can be used as a party admission against the state. And so I'm certain that in another case, my opponent would argue that police officer statements are not party admissions of the state because the police officer is not the party. Yet here, the state is arguing for a rule that says just the opposite. Justice Gould, you asked what I thought was a fantastic question as it relates to whether or not Title V superseded previous Maryland common law. I think it's a great question. An example came to mind, not as it relates to sequestration, but Maryland common law, if we think about the rule, the hearsay exception that allows statements made for purposes of medical diagnosis or treatment, that hearsay exception. Statements made for purposes of medical diagnosis or treatment are admissible as a hearsay exception. So under the common law, that rule only applies to a patient's statements, not to a doctor's statement. Yet, if you look at the plain language of the rule, which I think is 5-803-4, and I don't have it right in front of me, but I'm relatively confident that it does not specify that the statement is only admissible if it comes from a patient. So does that mean all of a sudden that the adoption of Title V and the rule allowing statements made for purposes of medical diagnosis or treatment suddenly now also allows a doctor's statements to come into evidence under that rule, even though there's no express language on the point and even though our common law does not allow it? I thought that was a great question, and that came to mind. Another thing that and I'll wrap this up here in the next minute and a half. Another thing that the state wants to do, a way that they want to kind of mollify the dangers, the risks that come from loosening sequestration rules, is by arguing that, well, you can cross-examine the police officer. You can get the police officer on the stand and you can say, well, officer, you've been sitting through this trial, though, so you heard what the other witness said. And while you heard what the other witness was saying, isn't it true you started thinking twice about what you were going to say? You know, you can, according to the state, that's a way that you can address it. Well, if we could do that, then why do we have sequestration rules at all? Why don't we just let all the witnesses sit in the courtroom? Because after all, we can just cross-examine them that way. Or ask voir dire questions to try to identify bias. And my opponent's statement that police officers might be perceived a certain way now compared to maybe however many years ago, that's not consistent with the empirical evidence, actually. That's not consistent with a lot of the studies. So in other words, that was speculation. My opponent essentially was speculating. It might be true, but there's no data in the record to support that position at all. And I see my time is wrapping up. Your Honors, based on those reasons, I'd ask the court to reverse Mr. Cromartie's convictions and remand this for a new trial, unless the court has any other questions.
I see no further questions, so thank you, Mr. Sharifi, and thank you both for your arguments. Case number 31 is submitted. And our next case of the morning is miscellaneous number 17, Martinez versus Amazon.com Services. Counsel, please approach. And Mr. Markovitz, when you're ready. We could, I know it's very exciting, but we're ready to start. Okay. Thank you.
May it please the court, Brian Markovitz and Andy Santillo on behalf of appellant Ms. Martinez. As class counsel, we represent almost 24,000 warehouse workers of appellee Amazon. Ms. Martinez, our client, is a former warehouse worker. We are here on a certified question from the United States District Court from Judge Herson as to whether the doctrine of de minimis non curat lex, the law does not concern itself with trifles, applies to the Maryland Wage Payment Collection Law and the Maryland Wage and Hour Law. This matter concerns workers going through mandatory post-shift security checkpoints to leave 3 warehouses in Maryland for the time period of November 2018 facilities. The class members followed the uniform policy of Amazon and clocked out at punch-out areas that were prior to going through these security checkpoints. As a result, they were not compensated for any time for leaving through security. After a very limited, and I want to emphasize limited, class-related discovery period, on November 18th, 2024, Judge Herson certified a class of workers and held in abeyance a pending summary judgment motion by Amazon, pending resolution by this court of the aforementioned question. So what's the answer? We think it has to be no. The doctrine does not apply. And there are several reasons why this question has to be answered no. Any of them on their own, which would result in it being answered no, let alone altogether. Now, as Justice Booth noted, the first place to check is the text of the statute and the regulations. And we think the Amaya decision, which was issued by this court less than 3 years ago, applies. And so there are several statutory construction principles that came out of Amaya that we think apply here. And as this court noted in Amaya, the same code, the Maryland Wage and Hour Code, the Maryland Wage and Protection Law, and COMAR are clear. And the court noted that the analysis of that should end, or could end at that point. Further, this court noted, and this is a quote, COMAR 09-12-4110 describes what constitutes work in Maryland and means what it says. And that's at Amaya 558-559. So what comes from that? What comes from that is silence cannot implicitly incorporate limitations on compensation under these wage laws and corresponding regulations. And there is some principles that came out of Amaya on that. This court noted, and this is another quote, this is Amaya at 555, "We decline to read the General Assembly's silence on such a significant matter, such as incorporating into Maryland statutes a federal law that limits compensation for work."
Yeah, but that was, Go ahead.
Amaya dealt with the Portal to Portal Act, which was an
did.
amendment that is not mentioned in the labor and employment article, which specifically defines the FLSA as the 1938 version. Here, we're dealing with a background common law principle, if you will. So aren't they different types
Sure.
of animals?
So let's hit this head on. We're talking about the Wrigley decision, which is from the Supreme Court, which discusses, Wrigley discusses the de minimis doctrine. And that's a tax case from the Supreme Court from the 90s. And the quote that is in that case that Amazon relies upon is, "This ignores the fact that the maxim de minimis is part of the established background of legal principles." But it also notes there that it is in all enactments absent a contrary indication. And there is significant contrary indication by the Maryland Department of Labor and also by the General Assembly. And that occurred in 1984. In 1984, Maryland Department of Labor issued 2 regulations. And they patterned themselves somewhat after federal regulations. So in 61, you had the de minimis regulation issued, which is 29 CFR 785.47. And then 7 years later, the U.S. Department of Labor issued a separate regulation. And that is at 29 CFR 778.223. And that is payment for non-productive hours distinguished, which is part of subpart C of the regulations. And that part C is payments that may be excluded from the regular rate of overtime. And that regular rate, so that's what doesn't count as hours of work. And if you look at that regulation, it reads a lot like the Comar regulation that I just cited to, which is 09-12-41-10, at the first part of it. But when you get to the second part, where it talks about what is compensable work, and this is in Section B of the federal regulation, it specifically references 29 CFR 785, and it also references 29 CFR Part 790, which is the Portal to Portal Act, which was rejected in Amaya. And that language from that federal regulation is not in the Comar Code. Comar did not adopt that part. So in 84, Maryland decided to go a different route. It followed what's hours of work, which is compensable time, being on duty, being required to go to the employer's premises, but Maryland broke from the federal regulation.
So it appears that the definitions mirror what the Supreme Court's language was in Anderson. And I agree with you that the federal regulation subsequently codified that background principle. But the fact that Maryland chose not to codify that, does that necessarily mean that the underlying principle is no longer there?
Well, it means that Maryland decided to go a different way to decide what's compensable time. Yes, that's what we believe. And it's not like Maryland did it once. They actually did it twice. There's a second regulation that we cite to as well, where they did it again in 84. So they broke from the regulations that were issued at 68, and that's the overtime break. And that is at Comar 09-12-41-14, and that was issued in 1984, 16 years after its comparable federal regulation, 29 CFR 778.103. And those two read very similar as well. They talk about the fact that if you work 2 jobs for your employer, all those hours count towards the 40 hours or being more to qualify for overtime. And they mirror each other's language. But the main difference between the two, if you look at the federal regulation, it notes in the last sentence of it that the principles for determining what hours are hours worked within the meaning of the Act are discussed in Part 785 of this chapter. So again, you have a federal reg that is relying upon what's compensable time based upon Chapter 785, which includes the de minimis regulation federally. And Maryland again decided, that's twice in that year, they decided to break away from what the U.S. Department of Labor was doing. And further, as we noted in our briefing, if you go to Section 305 of the Maryland Wage Payment Collection Law, you have payment on termination of employment. that's Maryland's code. That's kind of the big one in this law, right? That's the compensation you're going to get paid that you're owed if you're terminated. And that code was changed in 2008. And it specifically noted, it changed Section A and added a Section B. And in Section A, it says, quote, except as provided in Section B of this section, each employer shall pay an employee all wages due for work that the employee performed before termination. And we know what work is, right? This court decided that it means what it says in the Comar reg. Work is being on the employer's premises, on duty, or at a prescribed workplace. And then there's travel and meal periods as well. That's what work is. So this regulation notes, here's where you get paid if you're terminated, except for in subsection B. Those are the exceptions. Those are the only exceptions. And what does it say in subsection B? Does it mention de minimis? No, it just talks about accrued leave. So those are the exceptions.
Those are the exceptions, but the definition of work that's in the regs is the definition that was taken from Anderson, effectively. And Anderson, of course, recognized the de minimis exception. And I guess so when the federal regulation was implemented on de minimis, it seems to me that sort of pulled back on the de minimis exception, so that Maryland not adopting it, it was a restrictive interpretation of it. So that Maryland not adopting it, I'm not sure reflects what you're asserting it does.
Well, sorry, Your Honor, I respectfully disagree. I think in Wrigley you're looking for a contrary indication, and Maryland is indicating, right, that is a contrary indication by breaking from those regulations. And I think it's also breaking from the common law. There's nothing in the text of the statute, of the legislative history, anywhere that says that. And it's not just me saying this. They said that in Heimbach, the Heimbach case, which this court found very persuasive in Pennsylvania. They said it in the Vocaro case. The federal judge ruled on a New Jersey law. If you look at the New Jersey law, it says all hours of work. It reads almost exactly the same as the Maryland code.
Unreported federal district court case from New Jersey, and it wasn't, they just posited that they didn't think that the New Jersey Supreme Court would recognize it.
He did say that. That is correct. But he is saying that it does say all hours of work, and it means all hours of work.
But isn't that different language than we have in Maryland?
The law reads it's almost a verbatim. I don't have the code right in front of me here to do like an exact comparison, but it does talk about all hours on the employer's premises, on duty, or at a prescribed workplace. That's what I recall the New Jersey code saying. So it does read like our Comar regulation, and not alone. You know, the Heimbach, that law is also very similar and has that similar language in Pennsylvania. So again, from our perspective, Maryland is choosing to go a different route, and that would pull it out of Wrigley. I would also note that even if that's if you follow Amazon's logic for Wrigley, that Wrigley just is in the common law and that it's a thing that applies there. I would note that I don't know that Maryland applies Wrigley. I don't believe Maryland applies Wrigley the way that Amazon is asserting that it does. Because if you think about from a logical standpoint, first of all, the regulations that are to be put in Comar from the FLSA, they put it directly in, and they quote it, and that was noted in Amaya. It's put right in. Secondly, why is Maryland bothering to put the words de minimis into sections of the code if it's already there? And it's in the election law, it's in public safety, it was in another section, and very importantly, it's actually in the Maryland code. It's in the OSHA code, or the MOSH code, and that's at section, I think it's 512D. And what that regulation states is that it specifically instructs the Commissioner of the Department of Labor to issue regulations with respect to de minimis violations for health and safety. So why is the Maryland legislature bothering to do that if it doesn't need to, if it's already known in the law? There's no explanation by Amazon for these redundancies. And it's not just in Maryland
so
that
you're saying that because they didn't do it, that is a clear intent of their efforts to abrogate Maryland common law based on regarding the de minimis doctrine? The fact that they didn't do it, you take as a clear intent by the General Assembly to abrogate Maryland common law with respect to the de minimis doctrine.
Not sure I understand your question. I'm sorry.
Well, I mean, it's a tenet of law, right, that the Maryland common law is not abrogated by legislative enactment unless the legislative intent is clear.
Well,
Where's the clear legislative intent that you're talking about?
The clear legislative intent is that they did not include the words de minimis. That's correct. But they did in other parts of the code. They included it in a different section in the Labor and Employment Code. They included it in the Public Health Code. They included it in the Election Law Code. They wrote the words de minimis, meaning they wanted to apply that doctrine. So I do not believe that the application of Wrigley, as broadly as they state, applies in that fashion, such that it's just sort of assumed that it's in all the laws, unless it's expressly stated otherwise. Yes?
Can you clarify a point for me? As I understand, there are 3 separate lanes that the employees go through.
There are.
One of the lanes, the employees just breeze through without any delay, and that's if they don't take any devices onto the floor.
Well, Your Honor, so as this court well knows, you are supposed to rely upon the facts as found by the district court, and the district court did not make that finding. I know that they kept saying that they did, but he did not. And he specifically noted, first of all, the 3 lanes. So the first lane is the bag check lane. And he notes, and this is a quote, this is at the extract at 904. He notes, quote, "The undisputed testimony is that a line would form in the bag check lines with X-ray devices." That's lane 1. Then, in the next paragraph, he notes, quote, "Whether and to what extent a line would form in the divestment lane or the express lane is unclear." And that's what you're asserting. What you're talking about. We are right at the beginning of discovery. Our client testified about whether there was a free choice and whether she saw that there was time backed up there. But the record has just started here.
Okay,
and so
let me ask it a different way. Let's assume hypothetically there's a corporation, ABC, that has workers on the floor doing fulfillment, and they have to leave the company, because we're being asked to interpret the statute. That's why I'm asking this question.
Mm-hmm.
If it's the case that those who can breeze through because they chose not to bring devices on the floor can just breeze through, and those who choose to bring their devices onto the floor have to go through security. If that's the case, should Maryland statute recognize the de minimis doctrine in that context?
I don't think it does.
In other words, if the ones who breeze through aren't getting any overtime or any extra pay, why should those who make a choice to bring something onto the floor that they don't need to fulfill their job responsibilities?
So I would assert it this way. Section 3101 says that you employ somebody when you allow them to work. So if my secretary comes to me, for instance, and says she wants to work this Saturday, and I don't really want her to do that, right? But she does it, and I don't stop her from doing it, right? I still have to pay her for that time. And so I think that, that's what's recognized in the law, that those individuals, if you allow them to do something, allow them to work, then you have to pay them.
Well, does an employer have the authority to tell its employees or to bar its employees from bringing cell phones into their workspace?
I'm sure it could, sure, certainly.
Okay, so if that's the case, a company that gives the option to those employees, provided that they go through screening on the way out, why do they get extra pay over those who choose otherwise?
Well, Your Honor, so for this case that we're talking about here, I don't know that those lockers worked as well as they thought. There was some testimony about that. There was theft at the lockers. There were all sorts of problems that happened with there that were sort of outside of the fact pattern that as the district court found. But for those employees that are on that time, I would assert that that's something the legislature or the Department of Labor should issue. That it's not, and I mean this respectfully, for this court to judicially engraft some language in that doesn't exist there. And our point is that if there is some feeling that this rule that's not in the law, the text, or anywhere in the code, if that is leaving some people feeling that employers are vulnerable for certain types of things, then the proper way to handle that would be to go and get a lobby together and go down and either get the regs changed or the statute. And I would assert that nobody is in a better position to do that than the interest groups that filed amici here or Amazon that would be able to do that, and that would be the proper forum within which to do such a thing. And I would say that we have, we have the Heimbach case, and we have also, there's a case Busk, which dealt with the PPA. And there's these sort of parade of horribles that Amazon asserts. And, we've heard this before. We heard this before with Amaya about that if the PPA wasn't incorporated, that there were going to be all these frivolous lawsuits, things were going to go.
Right, but the PPA was a statute that we said that wasn't incorporated. We're talking about a common law doctrine, right? So even in Amaya, I wasn't on the court then, but even in Amaya, instead of taking 2 hours to commute, what if it took 30 seconds? Wouldn't that issue still be in Amaya? Couldn't that issue still be litigated in Amaya despite this court's ruling in Amaya?
Well, Your Honor, the case law that applies the doctrine of de minimis notes that if there's a contrary intention, and again, I think that the Maryland Department of Labor and the code.
We didn't say de minimis doctrine didn't apply in Amaya, did we?
No, it didn't come up. It wasn't an issue.
Because of the 2-hour commute. I mean, there's a 2-hour, time frame.
No, I understand that. Yes, it wasn't an issue. It was an issue in Heimbach. They did it all in one case. They had PPA and they also had de minimis. And the Heimbach case from Pennsylvania decided against both of those issues.
So the plain language of our wage enforcement laws doesn't mention the de minimis doctrine.
That's correct.
Comer doesn't mention.
Correct.
So there's no plain language argument that Maryland has adopted this federal common law doctrine.
That is correct, Your Honor. And
I understand it. We're being asked now to consider, because provisions of our laws mirror the FLSA, we must have adopted this common law doctrine somehow. Is this common law doctrine even sufficiently defined at the federal level that it could be construed that Maryland has somehow implicitly adopted it?
Well, I mean, I think it's probably sufficiently defined for the purposes of what Congress wanted to happen in the U.S. Department of Labor. But, without any textual history, without any legislative or regulatory history, there's no support whatsoever for putting this doctrine into the law in Maryland. There just isn't anything there. And, our position is that the court at that point is supposed to, can stop. And that was what was said in Amaya, that without that, then...
Federal case law hasn't even consistently applied this de minimis doctrine.
Yes, Your Honor, it's a hot mess.
Exactly.
It's, some courts are like 10 minutes. Some courts say it doesn't apply if it's a few minutes less than that. Whether it's regular time that's been done, if it's a class action, for instance, the Seventh Circuit, I think it's the Seventh, and Aguilar doesn't apply it. Kentucky, I'm sorry?
But the Fourth Circuit does.
The Fourth Circuit does apply. There's the Perez case.
And so the certified question is whether or not Maryland recognizes the doctrine. It's up to the Fourth Circuit and federal court, the federal courts to determine what how that doctrine is going to be applied in this case, right?
Well, again, Maryland hasn't recognized it. Maryland hasn't put it in. And this is a principle in Amaya, if Maryland law had to expressly disavow every statute, and I would assert also every common law principle. I mean, I can't think of one off the top of my head, but I mean, they had something about the impossibility doctrine or something. There's all these doctrines. Maryland would spend time just having to completely disavow all these, or they're incorporated into the law. I don't think that's how this works. And it doesn't make sense because they're putting it into other sections of the code. So why is the General Assembly doing that if it's not necessary? They would be doing that because they have to.
Counsel, I see you're going into your rebuttal. I have one quick question. Is this doctrine does this doctrine apply to help interpret what falls within the definition of work or compensable work? Or do we assume that the particular task is work or compensable work, but in the de minimis doctrine would be an exception to that?
So,
in other words, is it a tool to interpret these provisions? Is that what?
so you're asking, in other words,
in a general sense.
I'm sorry if I maybe could rephrase your question so I think make sure I understand it.
Sure.
You're saying, is it an exception to compensable work, or does it define what compensable work
Or
is?
does it inform how we interpret the statute?
The federal law statute?
Just the de minimis doctrine.
I don't think it does, Your Honor. No.
Okay.
Isn't it in fact antithetical to the history and purpose of our wage enforcement laws?
It absolutely is. And there's a couple purposes that I think it runs completely counter, one of which is the liberal interpretation, as said by this court in Peters, to be beneficial to the employee. It shifts the entire burden onto the employee for time that an employer asserts is not able to capture. And they have to bear the economic burden of that. And while some of these may be small amounts of time, you know, I think even Justice Scalia, he noted in Sandifer that the federal law is all about, I mean, he referred to it as trifles, so I don't know that I would refer to it that way, but small amounts of time. And he seemed to question, and this was in Heimbach, he seemed to question the continuation of this doctrine. And in the Heimbach case, they noted that that he was questioning whether it should still continue under the federal law. I notice my time's up, and I'll reserve. Thank you.
Okay, thank you, Mr. Markovitz. You'll have a little under 5.5 minutes for rebuttal, and we'll hear now from Mr. Schwartz.
Good morning, Mr. Chief Justice. May it please the court. Jason Schwartz on behalf of Amazon. I'd like to address 3 points, all of which I think support the conclusion that this court should answer the certified question, yes. Number 1, as a matter of Maryland common law. Number 2, the incorporation of the 1938 version of the Fair Labor Standards Act. I think this court in Amaya actually provides the instruction for how to get to the answer on number 2, which is a separate and independent ground. And then number 3, I'd like to speak to the public policy purpose of the statute and why an answer of yes for all employers in Maryland, small, medium, and large, the majority of which are small, is consistent with that public policy. So if I might, Your Honors, let me start with the Maryland common law. And my colleague referred to the United States Supreme Court decision in Wrigley. I agree that is the appropriate framework, but I think this court has actually spoken to that as a matter of Maryland law as well, including in re Tyrell A. And this court made clear that the common law is deemed to be incorporated into every statute enacted in Maryland, absent an express negation by the General Assembly. That the General Assembly is assumed to know that these common law rules exist and that they are incorporated into the statutes unless they say they're not. Here, we know that the state of Maryland, again, not federal common law, but state common law, recognizes what this court has referred to as the doctrine de minimis. Going back for decades, I'd point this court to the Capital Transit versus Bosley case in 1948, where the court made clear that it applied to a rate case, quote unquote, as in other cases. So it wasn't limiting the subject matter. The court applied it in 1989 in the Employee Retirement System of Baltimore case. It applied it in 1956 in the McKeon case. And my colleague has said that this court has never dealt with this in the wage hour context. That is true, but the chief law enforcement officer of the state, the Attorney General of Maryland, to whom this court has said his formal opinions of the meaning of state law are given great weight. The court said that in Town of Forest Heights. In 1969, the Attorney General of Maryland issued an opinion letter where he decided on two separate grounds, one being the Portal to Portal Act, which I know this court has rejected in Amaya, but separately, independently, the Attorney General said prison guards in the state were not entitled to compensation for certain time taking on and taking off their uniforms and in pre-shift briefings because the doctrine de minimis is assumed to apply as a matter of Maryland common law. The only reason that outcome changed was because then the regulations were amended, just like in Sandifer, by the way, to specifically address the tasks at issue. And then there was a negation of the common law going forward, that the guards had to be paid for that time.
I have a question about...
Of course, Your Honor.
Your premise about the common law adopting this de minimis doctrine. In cases such as Terrell, where that's occurred, there's been an unexpressed presumption that already existed in favor of the principle that we then adopted. The restitution case, for example, that had to do with an unexpressed presumption of harm and compensation that doesn't carry over. We've never had an unexpressed presumption that the de minimis doctrine would apply in the work setting. So I don't see how you translate common law cases in Maryland that don't have anything to do with wage enforcement laws, where we've relied on a presumption that this de minimis doctrine should apply.
Sure. Justice Watts, I would respectfully disagree. I think the court has made clear repeatedly, including in the Capital Transit case, that the common law doctrine of de minimis is applicable to all statutes, regardless of their subject matter, unless the legislature specifically negates that presumption.
The legislature here has done that. The legislature amended the work payment collection law to make it easier for small claims, small de minimis amounts of claims to be brought in Maryland. So that has occurred here in the work enforcement area.
And, Your Honor, if I might speak to that specifically as to the statute, and I think that also will go to my second point about copying the Fair Labor Standards Act, but let me just stick with the common law for a moment. The provisions that Ms. Martinez's counsel has pointed to as supposedly negating the common law de minimis doctrine are the following. Ms. Martinez points to the phrase, all compensation due for employment in Labor and Employment Code 3401D and 3501C1, and all wages due for work performed in 3505A. Respectfully, Your Honors, those provisions don't answer the question. They don't talk about what is actually work time. They just say once we've agreed on the work time, the wages do have to be paid. I'm not arguing that the de minimis doctrine says if I owe you $200, I can give you $199, right? We're talking about what is work performed and what is work time. Then my colleague says, well, the legislature added that word all. And by the way, it's not all hours worked. Some of the states he points to say all hours worked. Our statute doesn't say that. They added all before the compensation due. That was added in 1991 as part of a recodification. This court has been clear, including in Allen versus State, that recodification is not deemed to make substantive changes to the law unless it's a radical difference in the language. And more specifically, the reviser's notes for the 1991 recodification say, quote, that this was intended, quote, without substantive change. So it's certainly not that we can take the assumption that the legislature was intending to negate there. We also know how you could negate for specific tasks.
Do you dispute that the amendment was intended to make it easier for workers to bring small claims?
Your Honor, what I dispute is that there's no amendment that was intended to negate the de minimis rule.
The de minimis rule had never been held to apply, so it wasn't necessary for an amendment to negate it. You're relying on a general common law presumption that somehow it applies to all statutes, when in my view our case law says there's an unexpressed presumption, then it applies. So the legislature, the General Assembly would never have needed to negate what it had never found to apply.
Well, Your Honor, respectfully, that is true. The court has never held that. But again, the Attorney General of Maryland, the chief law enforcement officer of the state, did opine on that in 1969, specifically as to this point. And we know in order to negate, actually, Sandifer is a great example. There, the United States Supreme Court said, because there is a specific provision of the FLSA about clothes changing for unionized workers, it's right in the details, and that, as the Supreme Court explained, that's something that might take a small amount of time, but the legislature decided to deal with it. De minimis rule doesn't apply. If, for example, the Maryland legislature were to enact a provision that said time spent in security screening is compensable, then that's the level of detail that would negate the de minimis rule's general application in that scenario. Then my colleague points to the COMAR, and he says the COMAR uses the language all hours worked. That's not quite right. COMAR provision 09.12.41.14a deals with the provision of somebody who has two different jobs for the same employer. And what it says, just like its federal counterpart, is that all hours worked in both of those jobs are aggregated to figure out if you hit the 40 per week and trigger overtime. It has nothing to do with the issue that we're talking about. Then if you look at the, and the use of de minimis in other provisions of the code, the best example is within the labor area, the Occupational Safety and Health Act. By the way, as some of your honors may be familiar in that area of law, it's literally copied from the federal statute. That's how you get permission to have a state OSHA plan. And it's, again, an exception to the de minimis rule because it says a de minimis violation, which by the common law would ordinarily not be a violation, can result in a notice, essentially a minor action that is below a citation. So if anything, it proves my point. Then,
Counsel, can I interrupt for a second? Can you educate me on what the de minimis rule is and what it is not?
yes, of course, Your Honor.
Is it a sort of an absolute defense or immunity against a wage law claim?
No, Your Honor. The way that I would explain the de minimis rule is it's an ancient rule, obviously, that goes back to Rome that says the law cares not for trifles. What it means is that if there is some small deviation from a literal standard, that the law is not applied in a draconian way. I think Justice Gould gave a good example that, again, this court's not finding facts, but if somebody were to walk unimpeded through a magnetometer and continue to pace, that would be the kind of thing that would not violate the wage law. And in this case, I think, Justice Kilo, as you pointed out, the Fourth Circuit in Perez, we don't have to guess. They've actually adopted a detailed three-pronged test that governs the court's exercise of discretion in applying the rule. So it's not a Wild West. We know how it will work, and the district court has the tools to do it in the Fourth Circuit.
And it is a question of, it is a question of fact. Is it what's de minimis and what is not?
That's correct, Your Honor.
What's a trifle, what's not a trifle?
That's correct, Your Honor, and the district court will do that in the first instance, as is its role. Here, the question for the Supreme Court of Maryland is this doctrine incorporated in this law like it is presumed to be incorporated in every other law of the state of Maryland, absent express negation by the General Assembly?
So it is an interpretive device. It helps us, well, it informs the meaning of work, which is not otherwise defined.
I agree, Your Honor. It's actually, what I would describe it is, it's something stronger than an interpretive device because it's literally incorporated into the law. Wrigley and In re Tyrell A make that clear, that the common law is incorporated into the statute absent express negation. And then here we have a second and independent reason that leads to that same conclusion. And I think, Justice Booth, you pointed this out, that the provision that my colleague points to in the COMAR that has a definition of work is literally verbatim from Anderson. So this court, the question posed to this court by the United States District Judge was, does Maryland law incorporate the de minimis doctrine as explained by the United States Supreme Court in Anderson when the United States Supreme Court was interpreting the 1938 version of the FLSA? The answer to that is obviously yes, because our statute says it's modeled off the 1938 version of the FLSA. The regulation in COMAR that defines work literally takes the language of Anderson, and this court has said that when the legislature or the regulators use words that a court has defined, they are assumed to know what they're doing, that they are incorporating that meaning. The only difference, actually, is Anderson uses the word all. The regulation doesn't. I would argue that that actually means that there might be more room for a de minimis doctrine. And then my colleague says, well, but the federal Code of Federal Regulations later adds some things about de minimis that aren't here. And that we know from the United States Supreme Court, the reason they did that was actually to narrow the rule of Anderson. Here, our legislature and our regulators didn't do that. They adopted the rule of Anderson literally verbatim. And I think this court has already given the necessary guidance to answer this question if you look at Amaya, right? This court said in Amaya, which in fact cites Anderson, that our statute is modeled after the 1938 version of the Fair Labor Standards Act. Its language is parallel. It is intended to accomplish the same thing. Its definition of work should be read consistent with the United States Supreme Court decision in Anderson. Now, to be fair, it doesn't mention Anderson's de minimis rule, but it had no occasion to do so because, as you all pointed out, in that case, the facts were alleged to be a 2-hour wait and bus ride, right? That nobody was arguing that that was de minimis. Here, Amaya teaches us that the result is we copied the 1938 Fair Labor Standards Act. That's what applies. I'm not arguing the Portal to Portal Act applies here. If I was, this case would not exist because this is clearly a preliminary task. I'm just arguing that the Anderson definition was incorporated here. The plaintiff has made, Ms. Martinez has made 3 arguments against this, right? One is Amaya, and as I've just explained, I actually think Amaya is my strongest authority for you to reach this conclusion. 2, she says that de minimis words are not used. Again, they don't need to be used because the words of Amaya, or the words of Anderson were literally copied directly. So obviously that was the intention. And this court has said, for example, in Briggs versus State, that we can assume when words from a court decision are copied, the idea is to implement the effect of that decision. And then lastly, the plaintiff says the regulator was silent on this. Again, the regulator was not silent. Comar 9/12/41-10A uses the language of Anderson, except omitting the word all. So then finally, if you look at the public policy of this state, what I would respectfully suggest, Your Honors, is that this rule, the de minimis rule, works in harmony and concert with the rule of Amaya. In other words, to the extent that the statute of this state is intended to provide greater wage protection for workers, you've done that because the General Assembly chose not to incorporate the Portal to Portal Act. But the other bookend to that is the General Assembly did incorporate the de minimis rule of Anderson and the de minimis rule of the common law in order to protect employers, small, medium, and large, from having to track things like this. So if you think about this for a second, you've got every office building in the state. The amici point out to you, by the way, that the majority of employers in this state employ less than 20 people. So they leave their desk, they wait for an elevator, they get to the lobby, they've already signed out. Do we need to move the time clock to the lobby of the building? Or what if they're in the parking garage and they have to wait for the gate to come up and there's a line? Do we have to put the employer's time clock on that public property? Or I'm a mechanic and I work at a gas station on Rockville Pike. I clock out when my shift is over and a customer's car is blocking me from exiting the gas station. Does the time clock need to be right at the curb where I enter Rockville Pike in order to capture the time I had to wait to get my car out? This is what the doctrine de minimis is intended to do, so that the law is applied in a fair and not draconian manner. And then lastly, Your Honors, I just point out with respect to the other states, again, this court has been quite clear about how Maryland law is to be read. The Maryland legislature and the regulators are quite clear about the adoption of Anderson. But to the extent you look at those other states, you have a number of states reaching opposite conclusions that are relying on words all hours worked. Those words do not appear in the Maryland statute, and where they are in the Maryland regulation is taken out of context in the 2-job rule. Second, Some of those states, even with those words, are actually reaching the conclusion I'm suggesting you should, including Trester, the California Supreme Court case. They did not allow de minimis to apply to the facts of that case. And by the way, that was a case where the facts were already established, not a certified question like this at an earlier stage in the proceedings. But they did say, in an appropriate case, the de minimis rule might apply, just not here with the closing duties of a Starbucks manager that took whatever amount of time in that particular case. You've got the word all being used in Anderson under the 1938 version of the Fair Labor Standards Act that includes de minimis. So I would suggest all is not dispositive anyway, but that is a difference for these other states. And then you have several states that are coming out the way that I'm suggesting to you, in addition to, of course, the Portal to Portal Act. So first of all, pre-Portal to Portal Act, you've got the Attorney General of Maryland cites two other cases, pre-Portal to Portal Act cases, applying the rule of Anderson, one for cashiers who have to count the cash to turn it over to the next shift, and another one for somebody who has to come in early for a pre-shift briefing and grab their equipment, both incorporated in the 1969 letter. Then you have Illinois, which adopts this rule. You have Kansas and Wisconsin, who at least arguably adopt this rule. The National Retail Federation brief makes this point clear. And I need to apologize to the court. We cited a case that was actually interpreting federal law that we had mistakenly thought was state law. So I apologize for that error. Colorado has a regulation that has a de minimis rule. And again, the Fourth Circuit is quite clear. The law is not confused. There is a specific three-factor test, as opposed to the test that the plaintiff asked this court to literally make up from whole cloth to prevent the application of the de minimis rule.
So, Mr. Schwartz, when you're talking about application, I had a question I wanted to ask along that line. There's been a suggestion, certainly in the briefing by the appellant and some of the amici, that adoption or application of the de minimis rule can allow businesses to basically manipulate their procedures in order to deprive employees of time. And obviously that's a serious concern from a policy standpoint. But what's your response to that as to whether the application of the de minimis rule can allow that sort of manipulation to occur?
Let me first say the de minimis rule has existed since the outset of the Fair Labor Standards Act in 1938. That rule, the amici have pointed to no case where a court has said that that rule has permitted the deliberate theft of time from employees. So that the whole amicus brief that talks about this as a theft of time issue is completely off point. The de minimis rule is a rule that exists in every statute to prevent the draconian application of the law. In this area of the law, it's been applied thoughtfully. The Fourth Circuit has a three-factor detailed test that in this case, should you answer the certified question, yes, the United States District Court will then find facts and decide whether this security screening counts, whether it's de minimis or not. All of that is yet to be determined. But there's no one's talking here about stealing time from employees. The de minimis rule doesn't allow that.
Would an appropriate area of inquiry be to look into whether decisions were made and how the work day and the workplace is organized that might result in depriving employees of time when they're actually required to be on site?
I think that certainly can be part of the three-factor analysis as to whether this is work, whether this is regularly performed. There's also a provision that requires additional penalties for willful violation, right? So if you had some scheme that was designed, hey, we're going to shave X amount of time off every worker every day by, this secret scheme to try to misuse the de minimis rule, the law has tools to prevent that. No one is alleging that that was done in this case. In fact, I think everyone agrees that Amazon has, and again, these are facts to be found by the district court, but Amazon has 3 separate security lanes. If you don't bring anything, you can go in a lane that, even according to the plaintiff, the middle lane, I think the plaintiff said, takes seconds, right? So no one is alleging there's any kind of scheme here. But again, the facts are yet to be found, and when you're recognizing this rule for all businesses in Maryland, it does have natural limits to it. This court's limited Amaya, and as well as if there is intentional, willful deprivation of compensation, that is not permitted. I'm not arguing that the de minimis rule would allow that.
And so, just to follow up on that, so even if we were to say that the de minimis rule exists in Maryland, that doesn't mean that it will be applied in this case, right?
Exactly, Your Honor. The United States District Judge said, I have pending before me a motion for summary judgment from Amazon that asserts certain facts in the record. I haven't found whether those facts are undisputed or not, or whether they need to go to a jury. But before I rule on that motion, I first need to know, as an initial threshold matter from the Supreme Court of Maryland, do they even recognize this doctrine? And then if so, I have a 3-factor test I can apply under the Fourth Circuit's controlling Perez case, and we'll see. So, no, the outcome of our case certainly is not determined here today.
And even under Amaya, what if the shuttle took 30 seconds?
I agree, Your Honor.
Is there anything preventing the trial court in that case, in that situation, to say that the minimis rule applies to those facts?
So I thought that was a great question when you asked it to my colleague, and I agree with you 100%. If, in fact, it was a 30-second delay in getting to the construction site, then there would be a very good argument that the de minimis rule would apply. And this court's decision in Amaya not only doesn't prevent that, but I would suggest it commands that outcome, because this court was clear in Amaya, 1938 version applies. You even cited Anderson, which explains the definition of work under the 1938 version and recognizes the de minimis rule. And you said Portal to Portal Act doesn't apply, which again are very protective bookends for Maryland employees. Meaning that the pre-shift and the post-shift activities are theoretically compensable, but if they take a de minimis amount of time, they're not.
Counsel, can you identify the Maryland case that you're relying on for the principle that the de minimis doctrine applies to all Maryland statutes?
Yes, Your Honor. There are several cases from this court. I would say the principal case is Capital Transit versus Bosley from 1948, where the court said, quote, doubtless the doctrine de minimis, which is the phrase that's used by this court to refer to the rule, is applicable in rate cases as in other cases. I'm relying on the words as in other cases.
And that is clearly dicta. And in Bosley, the de minimis rule wasn't applied. And so you're relying on dicta from the Bosley case, and you're relying on a statement from Terrell, as I understand it, where there was already deemed to be a presumption of de minimis. I just don't find this premise that you're arguing to the court that there is common law that the de minimis doctrine applies to all Maryland statutes. I do not find that substantiated in our law.
I understand, Your Honor. What I would say is I'm not simply relying on Inree, Tyrell, and Bosley, although I think those cases are controlling, but this court has repeatedly applied the de minimis rule in various areas of law. In Employee Retirement System of Baltimore in 1989, this court found
very factual, specific holding. But you're extrapolating these cases to present to us a principle that the de minimis rule applies across the board unless there is some legislative intent or enactment to the contrary. And first, there's a faulty premise, I believe, with that interpretation of the law, that that's such a broad premise. And then assuming even, arguendo, if you're correct about that, in 1993, there was a very specific amendment to our wage law to specifically provide to allow workers to bring small claims that could be viewed as de minimis.
Your Honor, let me address both of your points. Number one, this court in many cases, including Tyrell, Bosley, Employee Retirement System, and McKeon, has applied the de minimis doctrine in various areas of law without any statement that it only applies to this specific area.
And without any statement that it applies broadly to every statute in Maryland.
Well, respectfully, Your Honor, I would actually say that in Inree, Tyrell, and in Bosley, this court actually did say it applies generally, and the United States Supreme Court has affirmed the same principle in Wrigley that my colleague quoted. He didn't seem to be disagreeing with that.
I'm focusing on your Maryland common law argument now.
Understood, Your Honor. Understood. And then secondly, no one has contended, including Ms. Martinez, that there is any provision of the small claims provision of the Wage Act that somehow negates the de minimis rule. Ms. Martinez is relying on other language that, as I've explained, not only doesn't support her, but incorporates the rule of Anderson.
Well, no one may be contending it. We look at the legislative history of acts and must take a de novo review in statutory interpretation. And the circumstance is a very plain amendment to our wage law that conflicts with this de minimis principle.
And I would respectfully disagree, Your Honor. Mr. Chief Justice, I'm prepared to waive the rest of my time unless the court has additional questions.
I see no further questions, so thank you, Mr. Schwartz. And Mr. Markovitz, you have the 5 minutes and 25 seconds reserved for rebuttal.
Thank you, Your Honors.
So I did notice he just waived 2 minutes of time, which is a small amount of time, isn't it? And his client wants you to judicially engraft a rule into Maryland law that is 5 times longer than that. 5 times, 10 minutes a day, 50 minutes a week. That's what they're arguing. That's what they want to have happen.
I don't. Where did they argue that?
That is what the common law most commonly, that the case law most commonly says about the federal de minimis rule, is that it's 10 minutes. That is what they that's what I remember them arguing, Your Honor.
That's inconsistent with how it was applied in Perez.
I believe that is inconsistent. Well, Perez, I can't remember exactly how they applied it in Perez, Your Honor. I'm telling you what I think their position is. I think they did mention 10 minutes in there.
Well, so, I assume that you're not arguing that if we say there is a de minimis rule that we have to adopt 10 minutes as the rule.
That's correct. I'm not arguing that.
And I'm interested in your response as well to a point I brought up with Mr. Schwartz dealing with the application of the rule. Do you think that it would be proper, if the rule applied, to examine whether a particular business practice was created or adopted with the intent of not compensating employees for work performed on site? Of
course, Your Honor. Yes, I think that is important.
And so if we found that, or if a court that was a fact finder were to find that that an intentional decision was made to put a clock or something somewhere so that employees would not be compensated for 30 seconds of their time, if that was intentional, then wouldn't that court likely find it was not de minimis?
I would say they would have to if that was the rule, Your Honor, yes. If it mattered why the intent mattered as to why, yes, I guess that would be correct. To the extent that this court does feel that there should be an adoption, I do note that we did cite to the Colorado regulation, which just went into effect last year. And to the extent that the court feels it has to do this, I think that the balance there struck was appropriate. Again, that's our opinion. Everybody obviously has an opinion on this. Just to address a couple of very quick points, because I do have limited time. That Attorney General opinion that he keeps citing to, and if you look at the Poe opinion that's cited in Amaya, that talks about the fact that it's perfectly acceptable to follow the federal law if there's no countervailing state law. And that came out before the Comar regulations were issued. That opinion is from '69, Comar's in '84. So that's why we believe that they came out that way. There was nothing at that time that had been issued by the Department of Labor. It's important to note that the Perez case follows 29 CFR 785.47. That it does talk extensively about that. That is what it's following. And as we stated earlier, Maryland went a different way on the regulations. So wanted to make sure that I pointed that out. Pennsylvania, New Jersey, and California, they have the same language from Anderson that we have. They have that language, and they did go a different way. They found it was counter to the policy. They found that all meant all. So, again, I think they're wrong about that.
Did California, I thought California didn't disavow the test completely, they just found it didn't apply in that circumstance.
Certainly, Your Honor. So that's very important. California actually has a de minimis code, and they cite to that in the opinion. It's California Code Section 355. It's called trifles. So that's why they kept that alive. They had an express provision in their code that required that. So Maryland, you know, if the de minimis doctrine is created here, judicially engrafted, if you look at the case law and what other states have done, it breaks into three groups. You have California, Kentucky, Massachusetts, New Jersey, New York, Pennsylvania, and Washington State. Those were all cited by either the parties or the amici, and those cases, there's nothing express, and they rule that there is not a de minimis doctrine. If you go to states that actually affirmatively do it, you have Colorado, which I mentioned, Tennessee and Ohio put it into either their code or their regs, and then you have Illinois. And they cite heavily to Illinois. They rely on the Mitchell and the Porter case. What's important about Illinois is Illinois actually has a reg that tells the Department of Labor to follow the U.S. Department of Labor. And it's at Administrative Code Title 56, Section 210-120, the use of federal definitions of various terms. And it states that for guidance in interpreting their act, the director may refer to the Wage and Hour Division of the U.S. Department of Labor regulations. So, and that predates those two opinions from Illinois. So that's a second group that has some sort of express support for that. And then there's the third group. He mentioned that they miscited a case. It's the Fox case. Didn't even deal with Wisconsin law. That's in Wisconsin. And then United Food Commercial Workers, which assumed without deciding, and so in other words, they didn't decide anything. So if Maryland does this, it's going to be the outlier of outliers, because there is no case, no court or state that has, without express support, created a de minimis rule by judicially engrafting it. See, my time's up. Thank you.
I see no further questions, so thank you both for your argument. Miscellaneous number 17 is submitted, and the court will now stand adjourned until 9 o'clock in the morning on April 4th, but the members of the court will be back out shortly.
All rise.